So, an application form is not enforceable under law. A lot of people come to me and say, Krish, I signed it. And it says, I have read and understood all the terms and conditions and I have signed it. How is it not applicable to me? I have given them money. I have signed a paper saying that they will forfeit and I agree to abide by the terms and conditions. And this is in the terms and conditions. How is it not applicable to me? I'll give you an answer. So this is my question to them. I asked them a question. Suppose one of the terms in this application form was, if you don't pay as per demand, booking amount as demanded, as and when demanded by the builder, then your wife will sleep with the director of the company. Suppose that was written into your application form and you signed it. Maybe you knowingly signed it, maybe you unknowingly signed it. My question is it enforceable? Can the director go to court and seek that your wife will sleep with him? Can that be done? They say, no, it's not enforceable. I ask them, why is it not enforceable? Why is it not enforceable? Now, they have an instinct. People have an instinct. This is not lawful. So they say it's not lawful. I can't, even if I sign, I said, you signed. You are her husband. Yes, I signed. I am her husband, but it is not enforceable. I say, good, correct, good answer. Let me give you another hypothetical scenario. Suppose there was, in the application form, there was a clause which said that your entire ancestral property will now belong to the company, to the builder company. Is it enforceable? They say no. Why is it not enforceable? Well, it's my father's property, so how can an application form that I sign be applied to my father's property? Correct. Good answer. So, everything that is in an application form is not applicable to you. Correct? Yes. But here I have paid the money. Why is it not applicable to me? The answer is because, my friend, it is a one-sided contract. It is in fact not a contract at all. And since it is not a contract, it is not legitimate. And if they have not entered into agreement to sell, it means it is not a contract and they cannot forfeit your amount because there is no breach of contract from your side if you have not continued to pay them as demanded. Their demand letters are extra contractual demands. They are outside of the contract. If the contract has not been signed, the agreement has not been signed. Let me go back to the basics because you need to understand the absolute basics of what is a contract, what is legal, what is a legitimate signature, when is a signature binding on you, when is a signature not binding on you. So let us begin. Let me start by giving you an example. You come to see me. You come to see Krish. You drive your vehicle to my house. Your vehicle is parked in my garage. A watchman gives you a receipt. He is my watchman, my security. He gives you a receipt. He makes you sign in a book saying, I have read the receipt and understood whatever it says, whatever terms and conditions are in the receipt. And the watchman says, sir, when you go out, please show the receipt and take your vehicle. You come to my house. We have a conversation for half an hour, 45 minutes. Afterwards, you go back. You give the receipt to the watchman. He looks at the receipt. He looks at the time. He says, sorry, sir. I cannot give your vehicle back. This vehicle now belongs to Krishnaraj Rao. You are shocked. You say, why is that? You say, sir, he says, sir, because in this receipt, it is written down that if I fail to come back within half an hour, then my vehicle will be forfeited. My vehicle will no longer be my vehicle. I fully understand. I have read everything in this receipt. And this receipt is binding on me. And therefore, he says, sorry sir, you went to meet Krishnaraj Rao at 5 o'clock. You should have returned by 5:30. It is unfortunately 5:45. You are 15 minutes late. This vehicle now belongs to Krishnaraj Rao. I cannot return it. Now you go to the police station. In the imaginary scenario, you go to the police station and the police station takes a look at the receipt. And they say, sir, did you sign this? You say, yes, I signed it. They say, sir, can you read? This is written in English. Can you read? Yes. You will say, I read it. Sir, there are these terms and conditions. In these terms and conditions, it is written that if I don't return from meeting Krishnaraj Rao after half an hour, I will willingly forfeit my vehicle. You have written it, sir, and you have signed. Krishnaraj Rao has not cheated you. See, he took your signature, you have signed, it even says, I have carefully read all the terms and conditions. And I promise to abide by the terms and conditions. Hi friends, this is Krish, the Urban Naxal. Friends, words are weaponized against us. Words are weaponized and used against the general public, and with words they create a web of lies and deceit and corruption and misuse of the law. I am talking about companies taking away your money, taking away your properties, taking away your houses, your flats, and not giving you anything in return. It's a dacoity that's going on, and the dacoity is done using words and done using the power of law and using your ignorance of the law. You, the common man, are ignorant. You don't know what is actually the law, what are actually your rights. That helps these guys take away your money and scare you and threaten you and tie you up and take away your right to speak and your right to defend your own money, your right to defend your property. So I am going to talk about contract, transaction, and the meaning of your signature, because there's a hell of a lot that you don't know about this and you're confused. And not only you, a lot of lawyers are confused. And I'm not sure if the judges are confused, but the judges don't give a flying fuck what happens to the common man. And the lawyers, for the most part, don't give a flying fuck either. They want your money. They really don't give a fuck. They may be truly ignorant of many aspects of the law. So I want to discuss aspects of the law which are important for you to safeguard your money. And I am going to give you examples of builders, builder companies, contracts, transactions, application forms, terms and conditions, allotment letters, various kinds of entities who are extra contractual, they are not part of the contract, the meaning of your signature, the meaning of various kinds of writing, the meaning of various kinds of rules that are made for you, but which are not really binding on you, but you think they are binding on you, and so you obey the rules. So we are going to talk about all this. First of all, I am going to start with a very shocking statement, and I am going to give you proof I need you to think about. The statement is this: your signature is not always binding on you. You may sign on something, but it is not necessarily binding on you. Even if you have signed something, it is not necessarily lawful for that person to take something from you. Your signature is not always enforceable, and I am going to give you various examples. First of all, what are the conditions for your signature to be enforceable? Legally enforceable. Number one, it has to be willing. If you are forced to sign on something, it is not an enforceable signature. Number two, it has to be informed. You have to understand. You have to understand everything that goes into that signature. You have to understand the whole transaction and what you're getting in exchange for that signature and what you are supposed to give because of that signature. If you are not fully informed, that is not enforceable. It is not legally enforceable. Number three, it has to be legal. It has to be lawful. That signature of yours is taken on a paper, and the paper and the writing of the paper has to be lawful. A lot of the times, the signature that you do make is either not willing, I'm going to give you examples, or not informed, or not lawful. The signature that you make is not on a lawful piece of paper. It appears lawful. It only appears lawful. Is every contract signed by you binding on you? No. No, it is not binding on you if it is not legal, if it is not lawful. You may sign pieces of paper which you think are contractual in nature. They look like contracts. To you, they may seem like contracts, but there's a lot of clever writing that goes into things which are not really contractual and you cannot enforce it. One example is Club Mahindra. When you take a Club Mahindra membership, you sign on an application form. You pay money to Club Mahindra. At no point in your documentation you will find Club Mahindra has, the authorized representative of Club Mahindra has signed. Anywhere. You are signing. You are signing in an application form. You are sending an application form from your email. They are accepting your application form, but the application form is not a contract. And at no point do they accept contractual obligations. You are accepting contractual obligations of various kinds. I will pay this. I will pay annual subscription fee. I will pay this amount for this kind of membership or blah, blah, blah. You are accepting their terms and conditions. You are accepting their rules. They are not even accepting a basic contractual obligation. Check it out. Let us study their documentation because I have read it. They are not accepting any contractual obligation. On the face of it, you think they are contractually bound to give you services as per what has been explained to you by their sales executive. But please remember, what has been explained to you by their sales executive is not down in writing, in their emails, in their written correspondence with you, in their PDF files sent to you. Nowhere are they saying, we will give you 7 days and 7 nights of holidays every year. They put ifs and buts. They put conditions. And those conditions are so many. There are so many conditions that if any one of those conditions are not fulfilled, they don't have to fulfill anything at all. They don't have to give you anything. Anyway, this is not a conversation about Club Mahindra. This is a conversation about contract. And I am telling you, everything that looks like a contract is not a contract, and everything you sign is not a contract. And every piece of paper that you sign is not binding on you. And your payment, whether it is a token to a builder or a booking amount or an expression of interest or earnest money or advance payment or deposit or the amount that you pay for locking in a unit or locking in a certain price. They have quoted a certain price. Now to lock in that certain price, you have to pay a certain amount. And they say, this is now our contract, an application form contract. The terms and conditions of application forms are binding on you. The terms and conditions of allotment letter are binding on you. No, they are not, because they are not a contract. There is only one contract, and that contract is the agreement to sell. That is the contract. That is the crucial contract. And if they have not entered into agreement to sell, it means it is not a contract and they cannot forfeit your amount because there is no breach of contract from your side if you have not continued to pay them as demanded. Their demand letters are extra contractual demands. They are outside of the contract. If the contract has not been signed, the agreement has not been signed. Let me go back to the basics because you need to understand the absolute basics. Let me start by giving you an example. You come to see me. You come to see Krish. You drive your vehicle to my house. Your vehicle is parked in my garage. A watchman gives you a receipt. He is my watchman, my security. He gives you a receipt. He makes you sign in a book saying, I have read the receipt and understood whatever it says, whatever terms and conditions are in the receipt. And the watchman says, sir, when you go out, please show the receipt and take your vehicle. You come to my house. We have a conversation for half an hour, 45 minutes. Afterwards, you go back. You give the receipt to the watchman. He looks at the receipt. He looks at the time. He says, sorry, sir. I cannot give your vehicle back. This vehicle now belongs to Krishnaraj Rao. You are shocked. You say, why is that? You say, sir, he says, sir, because in this receipt, it is written down that if I fail to come back within half an hour, then my vehicle will be forfeited. My vehicle will no longer be my vehicle. I fully understand. I have read everything in this receipt. And this receipt is binding on me. And therefore, he says, sorry, sir, you went to meet Krishnaraj Rao at 5 o'clock. You should have returned by 5:30. It is unfortunately 5:45. You are 15 minutes late. This vehicle now belongs to Krishnaraj Rao. I cannot return it. Now you go to the police station. In the imaginary scenario, you go to the police station and the police station takes a look at the receipt. And they say, sir, did you sign this? You say, yes, I signed it. They say, sir, can you read? This is written in English. Can you read? Yes. You will say, I read it. Sir, there are these terms and conditions. In these terms and conditions, it is written that if I don't return from meeting Krishnaraj Rao after half an hour, I will willingly forfeit my vehicle. You have written it, sir, and you have signed. Krishnaraj Rao has not cheated you. See, he took your signature, you have signed, it even says, I have carefully read all the terms and conditions. And I promise to abide by the terms and conditions. Now my question to you, is this lawful? Is it lawful if such a signature is taken on such a receipt? Is it lawful? Is it correct? Is it legally enforceable? Can I take away your vehicle? The answer correctly is no. But you know what? This is exactly what companies are doing. The vehicle is registered in your name. There is an RTO and that vehicle is registered in your name. And at no point of time did the vehicle get deregistered from your name and come into my name. When would that happen? When would your vehicle get deregistered from your name and become be transferred in my name? It would only happen if you signed a lot of papers explicitly selling your vehicle to me in response to a consideration, not for free. There would have to be a reasonable consideration. I can buy your vehicle. Maybe I can even buy it by paying 1 lakh rupees, but I surely cannot get it because you have violated some terms and conditions written in a receipt. Correct? This is what builder entities are doing to you. This is something like this is what builder entities are doing with you. Something like this is what even Club Mahindra is doing with you. They are taking away your money, they are giving you nothing, and then they are saying, our terms and conditions say this, and you have signed our terms and conditions. They are making you pay money, and then they are taking it away without giving you goods and services. This is the problem. I'm going to give you more examples. Let me give you another example. Now I am going to talk about a builder, a typical application form, a token, a booking amount. Builders take away your money by this method. You are called to the sales office. You are surrounded by sales guys who convince you that unless you book a flat on that very day, at that time, immediately, you are going to lose a golden opportunity and maybe you will never get it back. So they create a situation, they create this situation inside your head where you develop a kind of tunnel vision wherein you feel that it is extremely important at that point of time to book, because the flats that you like are about to get over. Those flats are going to disappear from the market and you will never get a good flat again. Or those flats are going to become costly, and right now it is the cheapest that you can get. If they are giving you a flat, selling you a flat at the rate of 70 lakhs, they will say, sir, tomorrow onwards, the prices will rise to 75. You are going to lose 5 lakh rupees because you did not sign and pay a token today. So we are asking for you to give us a token and sign here on this application form so that you can lock in your price of 70 lakh rupees. Otherwise, it will become 75. So, locking in the unit or blocking the unit is one thing. They say you block the unit, sir. Very limited inventory, it is getting over. Why it is getting over? How come it is getting over? Nobody will tell you that. Large project, sales office, but they will say, sir, the kind of thing you want, there are only 3, sir, only 3. Only 3 flats left. One is on 19th floor, one is on 7th floor, one is on 3rd floor. Everything else is over, finished, gone. And you get convinced. For some reason, you get convinced. You say, abhi nahi to kabhi nahi. If not now, then never. And you pay a token of 5 lakh rupees. Then you go home. Then you think. Then you think about the location of the property. Then you talk to your family members. Then you talk to your colleagues and you realize it is not appropriate for you for whatever reason. It is too costly. Maybe you are not able to raise that kind of loan. You may require loan of maybe say 50 lakh rupees or 55 lakh rupees, and your income does not justify a bank giving you a loan of 55 rupees. You are only eligible for 25 or 35 rupees, 35 lakh rupees or less, or your CIBIL score is bad. You realize all this and you go back to them, and then they say, no, sir, sorry, you have given 5 lakh rupees. That is less than 10% of our total consideration value of 70 lakh rupees. It would be 7 lakh rupees, which is 10%, and we can forfeit, sir. And we will forfeit. We will forfeit. We will take away your amount. And you are at fault, sir, because you came here. And they blame you. Then they will blame you. First, they will say you signed our terms and conditions. Look at the application form you signed. We will take away your 10% or 20%. In some builders like Godrej, take away 20%. Because you don't want to go ahead, because you don't want to give the next installment of another 5 lakh rupees or 10 lakh rupees, we are going to take away your amount and it is forfeited. Now, the word forfeited cannot be applied here lawfully because there is no contract. I'll give you 3 or 4 different reasons why it is not a contract. Number 1, the application form itself says that they are not holding the flat for you. The application form will say that we will consider, we will think, and we may reject your application without giving a reason. So they are not holding the flat for you. That is written in your application form. That's reason number 1. It is not a contract because they are not giving you anything. They are not even giving you an assurance. So your money is not a consideration paid for an assurance. There is no assurance. Read the terms of your application form. Now, if there is no assurance, if you're not getting a service, if you're not getting any goods, if you're not getting any kind of security, what is a security? A fixed deposit is a security. You give money to a bank. They promise to give the money back to you. That's a security. A promise to return the amount that you have paid to them is a security. Whereas a builder, through his application form, is giving you absolutely nothing. And in fact, even if he gives you an allotment letter, that allotment letter is not giving you title, right of any kind. Okay? It is not giving you title over the property. It is not giving you any kind of rights. It is only sticking more and more terms and conditions onto you. If you fail to abide by those terms and conditions and pay money as demanded, they say they will forfeit your amount. They may forfeit the entire amount. Godrej Property says we will forfeit 20%. Some other builders say we will forfeit 10%. Whether RERA allows it or not, they say they are going to take away your money without giving you goods, without giving you services, without giving you a security, without giving you anything. So that is not lawful. Let me give you an example just to make it clear to you how and why it is not lawful. Take this example. Because let me explain why I am going into this amount of explanation to make you understand that it is not lawful. The reason is, my friends, if you are not able to fight your own case or argue in the world, I'm not talking about in court, argue out here in the world, if you are not able to argue your own case with conviction, with understanding of the law and understanding of your rights, understanding of your constitutional rights, understanding of the rights that your nation has guaranteed you, it is accepted and understood throughout the world that if there is no transaction, a person cannot enforce a demand on you. Suppose you wrote and gave me, I will give Krish 1 lakh rupees tomorrow before midnight. I will give Krish 1 lakh rupees. You wrote it on stamp paper. You signed it. Your father signed it. Your wife signed it. Your son signed it. Can I enforce it? Can I take that piece of paper because you did not pay me 1 lakh rupees? Can I go to a court and say, my lord, these guys have promised to give me 1 lakh rupees and they did not pay. The judge will ask, promise to give you 1 lakh rupees for what, Mr. Rao? Why did they promise to give you 1 lakh rupees? What is the transaction? Is there a transaction? No. Did you sell anything to them? Did you give consultancy to them? Are you charging them 1 lakh for consultancy or any service? No. Did you loan money to them? Did you give them 1 lakh or even 50,000 earlier and then they are repaying you with interest? They are supposed to repay you, therefore they are your dues. No, my lord. No. Then why are these guys supposed to pay you 1 lakh? Because it says so on this contract, my lord. See, they have signed it. The judge will say, my friend, Mr. Rao, this piece of paper, you go and wipe your arse with the piece of paper because it is not a contract. It is not enforceable, Mr. Rao, because this is one-sided. There is no transaction. There was no loan. They don't owe you the money. It is not a salary. They are not supposed to pay you as a salary. They are not supposed to pay you as a commission. They are not supposed to pay you for any of those legitimate reasons. Why are they paying you? Is there a settlement? No, my lord. They signed and gave. Why did they sign and give? It is not legally enforceable. Get out. Get out. Fuck off. Don't come back. That's what a judge will tell me. Because a one-sided paper promising to pay money or anything or give property, one-sided, is not sustainable in law. It is not enforceable in law. Now I'm going to go back to the builder's application form. The builder's application form said that we can and we will forfeit 10%. It says it. There's a clause. You signed on it. If you had not paid to the builder would not be able to take it from you. Suppose you signed the application form and suppose you've given him 1 lakh, whereas the property value is 1 crore. So 10% of that is actually 10 lakhs. Can the builder go to court and take 9 lakhs from you? The answer is no. The builder cannot go to court and say that this guy owes me 9 lakhs. It is not enforceable. Why? It is not enforceable because it is not a contract, because it is not a transaction. That is why it is not enforceable, because it is not an anything. It is a trash piece of paper. That is why it's not enforceable. Why is it not a contract? Their lawyers will argue, builders' lawyers will argue in RERA that it is a contract. Now, RERA creates a very special set of conditions. Okay? And that is why I say that under construction property is bullshit. RERA creates a very special set of conditions, a very suspicious environment where you are not a contractee, but they will create a relationship. The RERA Act creates a relationship between the promoter and the allottee. Even though you have not entered into an agreement, they will say you are an allottee. What the actual fuck is an allottee? So there is a kind of a twilight zone that is created under the RERA Act. It's a law with a very suspicious agenda. It takes all the criminal things that builders do and turns it into civil. What builders do is criminal, but they have appointed this civil court, this quasi-judicial authority called RERA authority to adjudicate. That is a problem. So, an application form is not enforceable under law. A lot of people come to me and say, Krish, I signed it. And it says, I have read and understood all the terms and conditions and I have signed it. How is it not applicable to me? I have given them money. I have signed a paper saying that they will forfeit and I agree to abide by the terms and conditions. And this is in the terms and conditions. How is it not applicable to me? I'll give you an answer. So this is my question to them. I asked them a question. Suppose one of the terms in this application form was, if you don't pay as per demand, booking amount as demanded, as and when demanded by the builder, then your wife will sleep with the director of the company. Suppose that was written into your application form and you signed it. Maybe you knowingly signed it, maybe you unknowingly signed it. My question is it enforceable? Can the director go to court and seek that your wife will sleep with him? Can that be done? They say, no, it's not enforceable. I ask them, why is it not enforceable? Why is it not enforceable? Now, they have an instinct. People have an instinct. This is not lawful. So they say it's not lawful. I can't, even if I sign, I said, you signed. You are her husband. Yes, I signed. I'm her husband, but it is not enforceable. I say, good, correct, good answer. Let me give you another hypothetical scenario. Suppose there was, in the application form, there was a clause which said that your entire ancestral property will now belong to the company, to the builder company. Is it enforceable? They say no. Why is it not enforceable? Well, it's my father's property, so how can an application form that I sign be applied to my father's property? Correct. Good answer. So, everything that is in an application form is not applicable to you, correct? Yes. But here I have paid the money. Why is it not applicable to me? The answer is because, my friend, it is a one-sided contract. It is in fact not a contract at all. And since it is not a contract, it is not legitimate. What is a contract? Ideally, a contract is between two parties. Tripartite contract, tripartite agreement. Yes, it is there, but we'll discuss it at a separate time. But ideally, a contract is between two parties. So the two parties sort of handcuff themselves and each other. You are handcuffed to this company called Godrej Properties. Your handcuff says, I will pay this much amount. Godrej Properties handcuff says, I will deliver a flat to him of this description, of this exact description at this exact location at this time. So you have accepted to pay money at a particular time. Godrej Properties has accepted to give a flat to you of a specific description, specific size, specific location, and on a specified date. So you are handcuffed together. That is a contract. That contract is a handcuff that holds the two of you together. Can you have a situation where you are wearing a handcuff and Godrej Property is free? No. If you are wearing a handcuff and Godrej is free, then it is not a handcuff. That is, it is not a contract. I hope it makes sense to you. Only if both the parties are tied with contractual obligations and contractual obligations are clear, then and only then is it a contract. And then and only then is it legally enforceable. Now, please check in your application form or even on your allotment letter what contractual obligation is the builder accepting for himself. Or going back to the example of Club Mahindra members can check in their papers and tell me where exactly does it say that Club Mahindra is contractually obliged to do this every year. Contractually obliged. And I also want, in the case of Club Mahindra, I want to know the signature of the authorized representative of the company. Where is that? I am very sure you will not even have a signature of an authorized representative of a company, and I am definite that there is no contractual obligation that they are accepting. None whatsoever. Zero. So it is not a contract. Can a transaction have two contracts? I am asking you one more question. Your flat purchase transaction. Can there be two contracts or three contracts for one transaction? What is the transaction? I will pay X amount. You will give me a property. This is the transaction. My money, your property. Now tell me something. Is the application form the contract? If it is a contract, can you fill up the application form and can you go to the court and say, I have paid this much booking amount and now I am entitled to anything, property, anything, any small, I'm entitled to a portion of the property. I have some right, some title over the property. The answer is no. You paid 10%, but you have zero. You have nothing. You have nothing here. So is this a contract? No, because it is not enforceable. Application is not a contract. Also, application is not a contract because the flat is not fully described in the application. Only a unit number is written. The flat is not fully described in the application. Only in your agreement to sell, or what you call builder-buyer agreement, is the flat comprehensively described. Its location is described, its size is described. There is a little architectural drawing showing its shape, and details, what is the CTS number of the land, what is the land title, what is the nature of the title. So only the builder-buyer agreement or the sale-purchase agreement, only that properly records the entire nature of the transaction and what is the object of the transaction, which is the flat on the one side and the payment schedule on the other side. If everything is not in the contract, it is not a contract. That's another clue. Application is not a contract because everything is not there. It is not a self-contained document. So that is not a contract. So this is another reason why it's not a contract. I can give you numerous explanations for why an application form is not a contract. If it were a contract, you could have just gone and paid stamp duty on the application form. If the allotment letter were a contract, you could have just taken that allotment letter and gone to the registrar and paid stamp duty and had it registered and finished. You don't need anything else. But the allotment letter is not a contract. The application form is not a contract. The expression of interest form is not a contract, EOI, which is what some builders take. Nothing is the contract except the contract itself. And what is the contract itself? The builder-buyer agreement is a contract. If you think about an agreement as a marriage, it's a more or less equal relationship. It should be a more or less equal relationship. It can't turn into a master and slave relationship. There has to be some balance. If it turns into a master and slave relationship, then it's not a marriage, right? If it turns into a master and slave relationship with your builder, it is not a contract, right? There has to be balance. A little bit off, a little 5% here, 2% here, that is understandable because we live in real world conditions. But it can't be the builder side is up here and the buyer side is down here. So you're in a master and slave relationship with the builder. He's enslaved you. You are his financial slave. You are his economic slave. It can't be that, right? There has to be equity. Equity is part of the contract. So again, there can be many reasons why a contract is not a contract. Why a buyer is not a buyer but is actually a slave. Why a member, like a member of Club Mahindra, is actually not a member but is actually a slave. An economic slave. Okay? There are so many reasons and so many methods by which you are enslaved. Now, the whole thing is a web of words. There is a web of words that is used to enslave you. The web of what is a true law and what is nonsense, complete bullshit, what needs to be debated in courts, all these things are woven very cleverly together to create a trap for the ordinary common man. The web of words is what you need to understand first. If you understand the web of words, if you understand how you are enslaved, if you understand how inequitable these contracts are, how they make no sense whatsoever, if you understand what is a contract, what is not a contract, what is legally enforceable, what is not legally enforceable, then you can fight for your own liberty, your own economic and financial liberty, your own justice. You come to understand justice only if you understand this concept of equity, not equality. Equity. Equity is not equality. Equity is proportionality. Equity is a more or less fairness kind of thing that has to exist. For the law to exist, the soul of law, the heart of law is equity. The heart of a contract is equity. For a contract to be legally enforceable, it has to have equity. Otherwise, it is not a contract. You may have signed on a contract which does not have equity, which lacks the aspects of equity, but you have to read it and understand it. You have to read those clauses. You have to understand that all terms and conditions cannot be applicable to you even if you have signed them. All agreements, all instruments, not all of them are sound. You have to understand it. You have to understand the inequity that is in these webs of words. These webs, these traps fashioned with words for you, the common man. Friends, as always, if you find that you have a doubt that you are in a problem because some company or some big entity has taken away your money or is taking away your property or threatens to take away your property in the name of redevelopment or wants to take away your money in the name of a club membership or there is a lot, or an employment and a bond that you have signed, etc., etc. A bond that you have signed is not necessarily legally enforceable. So there is a lot to understand there if you are at the receiving end, especially of some such thing, if you have been trapped in the web of words. Please contact me. My WhatsApp number is 816-947-1229. Let us talk about it and let's figure out how to break out of this web of words. How do you break out? There has to be a plan. Is it difficult? Of course it's difficult. Of course it's difficult. That's why it's a web of words. They've constructed it. Top brains, top lawyers have put their minds together. They've been paid crores of rupees. Major lawyers have been paid crores and crores of rupees to write these financial traps and to defend the company unlawfully, uphold their unlawful, illegal activities, but uphold them very ably, and judges turn a blind eye to it. And you, because you are not able to pay a top senior counsel or anything of that kind, usually your case goes for a toss. The judge will trash your case. Happens. Unfortunate, but it happens. You gotta fight. So fight. Call me. Let us discuss how to fight. What are the methods to fight? By what means can you try to break out of the trap? Let us discuss it. I am Krish, the Urban Naxal. Jai Maharashtra, Jai Hind, Jai Jawan, Jai Kisan.